I'm Melvin L. Raymond. Welcome to Raymond Law Live. First, I want to give a shout out to Better Family Life and the Sims and Bailey Law Firm. Recently, within the last week or so, there was a conference, a crime reduction conference held in Kansas City, Missouri. One of the participants in that conference was Better Family Life. The President of the United States recognized Better Family Life and gave an award to James Clark, who is on the staff of Better Family Life, in recognition of their effort and their initiative at crime reduction. So kudos to James Clark and Better Family Life. As you know, crime is such a problem in the St. Louis area, and the initiative of Better Family Life to reduce gun violence is commendable, and we want and can encourage Better Family Life to continue the good work. The Sims and Bailey Law Firm is a law firm here in the Central West End providing quality legal representation and expert representation. You can contact them at area code 314-534-0800. Let me remind you, mention again our new feature, which we call What's Your Need. This new tool allows you to tell us what topics you want us to cover on future broadcasts. Simply call us or email us with your topic of choice, and we will get to that as soon as we can on a future broadcast. I will give you the information for our phone number and how to contact us with your choice of topic before the end of the broadcast. Now, on today's broadcast, we are going to continue with child support. We've dealt with child support for the last two broadcasts, so we're going to continue with that today. And also, we're going to be dealing with a new topic, landlord-tenant matters. So first, let us continue with and complete our presentation on our discussion on child support. You can post your questions or your comments at the end, at the next segment, and I will answer as many questions or comments as I can. Now, I want to deal with, as far as child support, with the determination of father and child relationships. In other words, paternity cases when there is a legal action to establish paternity. Now, in situations where a child has no legally presumed father, an action to determine paternity or the existence of a father-child relationship can be brought by the child, the mother, or the person who has legal custody of the child. Now, let me deal for a moment with the presumption of the existence of a parent-child relationship or the presumption of paternity. There are a few instances when the law presumes that there is a father-child relationship, and this presumption is rebuttable. So, the first instance where the law of Missouri indicates that a man is presumed to be the natural father of the child is when he and the child's natural mother or have been married to each other and the child is born during the marriage or within 300 days after the marriage is terminated by death, annulment, declaration of invalidity, or dissolution, or after a decree of separation is entered by a court. So if there is a child born during the marriage, then the husband will be presumed to be the natural father of the child unless that presumption is rebutted. And it is possible to rebut a presumption that a child born during a marriage is the child of the husband. The second instance where a man is legally presumed to be a natural father is before the child's birth, he and the child's natural mother have attempted to marry each other by a marriage solemnized in apparent compliance with the law, although the attempted marriage is or may be declared invalid. Here it is, what's the key here is that if the parents or the he and the mother, they attempt to be married, then the law will legally presume that he is the father of the child. Thirdly, a third instance where a man may be presumed to be or is legally presumed to be the father is after the child's birth, he and the natural mother have married or attempted to marry each other by a marriage solemnized in apparent compliance with the law. The marriage does not ultimately have to be determined to be valid as long as he and the mother attempt to be married. And one of the fourth ways that a man is legally presumed to be a father is an expert. An expert concludes that the blood test or a DNA test show that the alleged parent is not excluded, and that the probability of paternity is 98% or higher, using a prior probability of 0.05. So that's 99.5%. If a paternity test, either blood, and the methodology for determining paternity today, DNA is relied upon much more frequently, but there can be a blood test for paternity also. So the last way that a man is presumed to be the legal father or natural father of a child is the paternity test, and the results show that he is not excluded and has a probability of 98.5% or higher. Now, as I said, this legal presumption of paternity in these four instances I mentioned, that is rebuttable, and an instance where this can arise, and I've handled cases where this has happened, is the parties are married and they are separated or not separated, and a child is born during the marriage. The father or the husband would be legally presumed to be the father. So what has to happen if there is an action for dissolution is that the putative father has to be brought in as an additional party to the divorce proceedings. The court would appoint an attorney, or call a guardian ad litem, for the child, and then a determination of paternity would have to be made through a paternity test. And so there's a third party, the putative or not the presumed father, but the putative father, or the person the suspected father has to be, there has to be a paternity test, and if he is not excluded and there's a probability of 98.5% or higher, then that person would be legally determined to be the father, and the court would enter a child support order and a finding of paternity, and that will rebut the presumption that the husband is the father of the child because the father was born during the marriage. Now, paternity cases, as I mentioned, that's where the parties, the father and the mother, are not married and a paternity action is brought. And if that happens and you receive a notice, you have to receive a notification by law. If you are suspected to be a father and an action is brought by the child, the mother, or the person with legal custody, then you have to be given written notification, which has to be attached to the lawsuit, to the paternity petition, and the notice has to include notice that if you do not respond to the action, then a judgment of paternity may be entered against you, and you may be ordered to pay child support, medical support, or reimbursement to someone for support previously provided to the child. So, any man who receives a notification in a paternity action, gets served with papers, you do not ignore those papers, because you could end up having a default judgment of paternity and a finding of the existence of a father-child relationship, and a child support order or a medical support order could be entered against you. The notification in a paternity action also has to indicate that you have the father, or the person, the suspected father, has the right to contest that he is the father of the named child, and the right to request genetic testing to prove whether or not the suspected father is indeed the father. And if there is, you can request the suspected father can request genetic testing. That could be, it probably be a DNA test, at the expense of not the suspected father, but the child or the mother or whoever it is that brought the paternity action. So the suspected father does not have to pay for the genetic testing to determine whether or not he is the father of the child. Lastly, the failure to provide support to a spouse or a child or a stepchild could be a criminal matter, criminal non-support. Could be a criminal offense. You should be aware of that. And the criminal offense of non-support occurs when a person commits the offense of non-support if he or she knowingly fails to provide adequate support for his or her spouse, or a person commits the offense of non-support if such a parent knowingly fails to provide adequate support which such parent is legally obligated to provide for his or her child or stepchild who is not otherwise emancipated by operation of law. So not only is a parent, but a person can be subject to criminal non-support for not supporting a spouse or a child, as I just indicated. Now, when is it a criminal offense? It is a criminal offense. That's a Class A misdemeanor if the amount of support is less than 12 months of support. Less than 12 months. It's a Class A misdemeanor. If the person fails to support a child or a spouse for 12 months, then it is a criminal non-support offense. So I want you to be aware of that as far as support. Don't forget, for questions, you can post your questions or comments you can post them, and we'll get to those questions and comments at the end of the presentation and before the end of the broadcast. Now let's move on to landlord-tenant matters. Landlord-tenant matters. This, of course, applies to renters and also to landlords who rent property. Now, court actions involving rent and possession, those cases can be brought, of course, when a tenant fails to make a payment of rent at times set by the parties. So, again, failure to pay rent at times set by the parties. Now, when you bring a suit, or landlord brings a suit for rent and possession, there's certain conditions have to exist. And the first one, of course, is that the rent must be due and payable. So your tenant has to be at least 1 month behind in rent. And it doesn't have to be more than 1 month. If a tenant is behind in rent 1 month or more, then the landlord can bring a suit for rent in possession. The second condition for bringing or recovering possession by way of a landlord-tenant suit is the payment must be demanded by the landlord. And the demand can be made by serving them with a landlord rent in possession suit. And the third thing is, in terms of the court action itself, the landlord must file a statement verified by an affidavit with in the Associate Circuit Court in the county where the rental property is located, Associate Circuit Court, and you have to indicate in the statement verified by an affidavit the terms on which the property was rented. That typically includes the amount of the rent, of course, the monthly rent, and other conditions if it's a rent lease or not. That would be the term of the lease unless it's a month-to-month lease and so forth. And you also have to indicate the amount of rent actually due to the landlord at the time that the landlord suit is fought. And you have to allege in the landlord suit that the rent has been demanded from the tenant or the person occupying the property. So those things are needed before a landlord can bring an action for rent and possession. Now, in addition to rent, the landlord can also add a claim for any other unpaid sums that are provided for in the lease. So that could be late fees, it could be utilities, water, and such. So when the landlord brings a rent and possession action, they can add claims other than just rent. The summons, after the suit is filed, the summons and the petition can be served by personal service, or it can be posted on the premises. Posting, of course, means putting a copy of the summons and the landlord petition on the property, and that would have to be done at least 10 days before court. And the landlord also has to mail a copy of the summons and the petition to the tenant. Also, the tenant can be personally served when the sheriff or could be a special process server hands the copy of the summons and the petition to either the tenant or someone at the property, a member of the household who is at least age 16 or older. If they leave it with someone there and they accept the service, then that's good personal service. Now, if there is service by posting, the court cannot issue a money judgment, but only a judgment for possession. So if there is a posting only and no personal service, the court can only issue a judgment for possession. And if they get a judgment for possession by the landlord, then of course the tenant can be evicted after there's a judgment. And landlords can sue also. Sometimes landlords, even if they're owed rent, they can sue for possession only. And that usually happens in instances where the landlord cannot get personal service on the tenant and they still want to evict the tenant, so they will sue for possession only and not sue for back rent. That doesn't mean that they can't later bring a separate suit for the back rent that's owed to the tenant. So if you have any questions or comments, you can post them at this point. There are instances or situations where tenants, because of the condition of the rented premises, that is, the conditions or the place is not in sufficient repair or adequate repair, or it could be various things that could constitute violations of the housing code. And that could be any number of things. It could be leaky ceiling, it could be defective electrical wiring, it could be rodent or insect infestation. The violations have to be of the housing code on the premises has to be substantial violations of the applicable housing code. If that happens and the tenant stops paying rent because the conditions have not been corrected, or until the conditions are corrected, then the landlord still can bring an action for rent in possession. And it's not a defense, tenant, if you refuse or withhold rent. In the instances where action is brought, you have to, in order to raise the violation of the housing codes and the condition of the premises, for that to be a good defense, you have to pay the rent as it becomes due into the court. If you withhold rent because of the conditions of the property, that is, the property not being in poor repair and so on, if they're substantial enough, then you have to pay the rent into the court if the landlord brings a rent and possession suit against you. You just cannot withhold the rent and then claim as a defense that the property is in violation because of conditions making the property not habitable, and those conditions constitute violations of the housing code. Don't forget, you can send questions or comments about the landlord-tenant or about child support, and I'll try to answer as many questions as I can. We'll be getting pretty soon to the final portion of our broadcast, so I'm going to continue on with the landlord-tenant matters. Now, as far as month-to-month leases, a landlord can terminate a month-to-month lease whether or not the rent is in arrears. So it's not relevant as far as a month-to-month tenancy. The landlord still can bring a rent, and he can terminate a month-to-month lease. You have to be given 30 days notice. 30 days notice for a landlord to terminate a month-to-month lease, and that's as opposed to a lease for a term, a written lease for a certain term, either whatever the term could be. It could be 6 months or it could be a year. So month to month, the landlord can terminate that lease with proper notice, and that's only 30 days notice. Let me also mention, as I get to the end of my comments on this topic, about when a tenant abandons property. When a tenant abandons a rented property, what can the landlord do as far as situations where a tenant abandons property? Basically, if that happens, the landlord is legally required to notify the tenant about the property being abandoned, and there's certain things that have to be in the notice if there's an abandonment. So that they have to send notice to the tenant, of course, and this occurs usually in situations where the landlord has a reasonable belief that the tenant has vacated the premises and intends not to return, and the rent is due and has been unpaid for 30 days. And if those two things occur, that is, the landlord has a reasonable belief that the tenant has vacated the premises and intends not to return, and the rent is at least 30 days past due, the landlord can then post a written notice on the premises, the rented premises that is, and also mail a notice to the last known address of the tenant by first-class mail and certified mail, and letting the tenant know that the rent is due and has been unpaid for 30 consecutive days, and that the landlord is under the belief that the tenant has moved out and abandoned the property, and that the tenant should remove their possessions from the unit, or the landlord will dispose of them unless the tenant responds and removes the property within 10 days. So in an abandonment situation, the landlord can lawfully, after giving proper notice and waiting the 10 days, they can remove and dispose of property that the tenant has left on the abandoned formerly rented premises. So we're at the end of our segment on the topic of landlord-tenant, and I don't think I have any questions or comments. Now, if you want to contact us, you can go to RaymondLawLive.com or Facebook.com/RaymondLawLive, or you can contact us at our office telephone number, area code 314-534-2800. So that's how you can contact us. And you can also contact us at the same numbers for legal representation. Thank you for listening, and we will see you on the next broadcast. Remember, when you fight, know your rights.